Okay, we're now live. And I have to let Marley know that we're live. I don't know if you can hear in the background, but I'm gonna let Michelle go over the new draft first. Then we'll hear from Evan Meenan, Tucker Jones, and Jennifer Micah from Department of Children and Families, and anybody else who wants to weigh in. Okay.
Okay, so Senator Sears, is it okay if I share the screen and put the draft up?
Yep. Except I can't see people, so just jump in. I won't be able to see you raising your hand or whatever, so please feel free to jump in if you have questions.
So for the record, Michelle Childs, Office of Legislative Counsel, and it is a long bill, so I'm just going to go through the changes that you've asked for consideration for today, and that language is highlighted. Down to, let's see. First changes. So if we're looking at qualifying offenses, and you look at the language that's on page 4, sorry, I keep going back and forth there. So recall that in the bill that came over from the House, what a qualifying offense means is it's all misdemeanors except a certain list of crimes. And there were 2 crimes there that you thought you wanted. And those are on page 4, line 12 through 15. And the first one being the aggravated disorderly conduct, and the second one being neglect of duty by a public officer. And that should be struck. I'm sorry, that 14 and 15, that's supposed to be struck. I think sometimes when I do this, editing gets a little confused because they're like, wait, you're not supposed to have a strike through and an underline in the same thing. And I should be a little clearer with editing about that's intentional for a reader assist at this point. But those are supposed to both be out. So that is the first change. Down too far. All right, I'm making everybody dizzy.
Before we move on,
sure.
I just noticed bottom of page 4, violation of section 1455 of this title related to hate motivated crimes.
Mm-hmm.
Are we allowing expungement of hate crimes?
No, this is the things that are not eligible.
Okay.
Yeah.
Right. Okay.
Remember, it's everything but this list.
Got it.
Yeah, I had that same question on burning of a religious symbol.
Felonies is just the opposite.
Oh, thank you. Yeah.
Exactly, right? Yeah. It's only the felonies that are specifically listed which are eligible. So, let's see, I should have which pages these changes are on.
Michelle, one question. Are we sure that careless and negligent driving is part of the bill? In other words, if there's no bodily injury or death resulting from careless and negligent driving, they can get it expunged.
I believe so, but I'll double check. I checked it when you had that inquiry from Mr. Silver, but I'll go back and double check.
I've had a couple of other inquiries from people, and I really think it makes sense because many DUIs are pled down to careless and negligent when the person's at 0.08 or anything lower than 0.10. Frequently, state attorneys will take a plea for careless and negligent, and it would be unusual for the careless and negligent not to be expunged, but you can expunge the DUI, under certain.
Right. Well, I'm pretty sure careless and negligent driving is it's a misdemeanor, and it's not listed as one of those excluded, so it should be eligible. But I
just want to make sure.
Check. No. Sure. So the next change is on page 14, and so this is going to the heart of the expungement statute, starting out looking at who is permitted to petition for sealing. I'm sorry, I didn't mean expunsion, for sealing. And you'll see there on page 14, I struck the first one, A1A, and with respect to a person who is convicted of an offense for which the underlying conduct is either no longer prohibited by law or designated as a criminal offense. And that's because you'll see it in a few pages down. I created its own separate section because this was in response to Senator Benning's concern that why shouldn't these be expunged if it's no longer a crime or no longer even prohibited by law? The preference was to have expunged instead of sealing. And so I've created its own section so that we can be very clear that this one section that we're dealing with here is just with sealing. And so we're not kind of mixing the two in one statute.
So it will be sealed and not expunged? Is that what?
No, I'm taking it out of the sealing
Yeah.
structure, and you'll see I have a new expungement piece down below. So this is just, I just highlighted where I had to kind of re-letter some things. There's also something at the bottom of page 15 that I took out and would certainly encourage witnesses to comment on, which is there's this provision that was picked up from current law, and it talks about the section shall not apply to an individual who's licensed as a commercial driver who's seeking to expunge a felony record committed in a motor vehicle. Well, this whole structure doesn't allow for felony motor vehicle offenses to be expunged or sealed. So it just seemed to, I'm not sure, it just seems like a relic that's gotten put through over the years. And I don't think it makes any sense any longer, but certainly if anybody, if I'm missing something, I would encourage the witnesses to certainly let me know.
Tell me more about that. It doesn't make any sense anymore that a person who, in other words, this person can't have their record expunged if they had a CDL.
Right, this is saying specifically a statement, you can't expunge a felony driving offense if you're a CDL person. Well, you can't anyway under the structure, so you don't need a statement affirming that because it's not one of the eligible, it's not one of the qualifying offenses.
Okay.
So
So in other words, they can't be expunged anyway.
right. So just moving down. So we're gonna go to page 18.
You have a highlight on C.
Those are just because I was just changing the lettering, and so if people were looking at cross references, but I didn't change anything substantively there. So page 18, this is where I created the new statutory section dealing with the expungement of offenses no longer prohibited by law or designated criminal offense. And I basically took the same substance that was in the earlier section and just moved it to its own section so that we're not kind of mixing the expungement and sealing processes. And so I didn't change any of the standards or the substance there. So you just see that, the person would need to file for a petition, but they would be seeking expungement, not sealing. And they have to have completed any sentence or supervision for the offense, paid any restitution. And then there's that section B, starting on line 14. Again, this is all what's been in there currently, which is that, and this is just the subsection B is dealing with the issue around the cannabis when you did the decrim and the legalization and the difference between 1 ounce and 2 ounce, and that's just been that's been in there for a while.
And do we know how many of these cases there are?
I do not.
Okay, maybe we should hear from Judge Zone as to, is this going to be a flood on the courts? But I'm not saying it wouldn't be
I'll
done.
double check, but I think this is current law.
It is, why are we having to put it in then?
Because we are changing the existing law and that section of law to be a sealing statute. and changing the standards. And so I'm taking it out of that one section and moving it to another section, but the language is the same.
So in other words, anybody presently who has a very old marijuana conviction can get it expunged. Is that correct?
Correct.
Okay, no, it's not changing anything.
Well, it isn't,
Right.
but it's important to remember that what this bill does in the bulk of it is makes it a one-track system for sealing rather than expungement. That was what the governor wanted to have happen. The Justice Oversight Committee agreed, and others. And so what this bill really does is create
Frozen.
what's the matter with my internet today, but I'm frozen. Am I
Oh, you're okay now, Dick.
Okay,
okay? So we have to keep in mind what this bill is as a result of concerns expressed by the administration with S7 that we passed last year. We went to the Justice Oversight Committee. They talked about having a one-track system of sealing, and that's what they approved, and that's what the House dealt with, is trying to make it a one-track system. However, there are certain things that should still be expunged, one of them being criminal offenses that are no longer criminal, and people who have a deferred sentence. It's always been expunged, and it shouldn't change that. So that's why Michelle has created a new section at Senator Benning's point, which is well taken, that if it's no longer a crime, it ought to be expunged and not sealed, because it's a very different situation. And so I realize it's somewhat confusing, but we have to keep in mind that this is the compromise that we're trying to work out with the administration. And the House worked very diligently to get to a sealing, a one-track system of sealing. And that's created a lot of angst. And I know that. And as we go through the bill, we need to basically understand that there are still things that could be expunged. As I said, this would be things that are no longer a crime. Senator Benning pointed that out. And further, things that if you have a deferred sentence, it should be expunged, because it's always been that way.
Okay.
Is that helpful?
Okay,
yes.
Yes.
so I'm going to move to page 20. And this is the section that's dealing with what is the effect of sealing. And this is the section where there are, in current law, the exceptions to sealing, which means that, who can see a sealed record. And you'll recall that in the bill as it came over from the House, some of the primary changes is that under current law enforcement has broad access to sealed records for criminal justice purposes. So it's a pretty broad authority to access sealed records. And in the House passed version, that was eliminated. And then what they put in was essentially two look backs, one for sentencing, where you could have criminal justice agencies looking back for a certain number of years for purposes of sentencing for subsequent offenses. And then the other big one was for DOC to be having a certain period of look back for purposes of doing risk assessments and for supervision on subsequent offenses. And so what you asked me to do was to kind of start over on the exceptions for sealing, but use the Title 33 law, juvenile law, with respect to who has access to sealed juvenile records under current law. And you've had that law for I think about 15 years around how that works. So after a certain period of time, juvenile records are automatically sealed. And then this structure that I put in here is really verbatim what is currently the access that different entities have to sealed juvenile records. So I'll walk you through that. So you'll see there at the bottom of page 20, so subsection C and we're just dealing with convictions here. So except as provided in the subsequent ones, inspection of files and records included in a sealed record are only to be permitted by the court only upon petition by the person who is the subject of the records. Okay, so that's kind of the default, is it's only if you're the subject of the records do you have access through the court granting access. The next one is subdivision 2, and so the new language, I'm sorry.
The person who is the subject of the records is the one who petitions. But then you have a comma, and only to those persons named in the records. So if I'm the subject of the record and I petition, anyone who is thereafter named in the documents is able to get a copy of that?
I don't know, I'd have to go, I haven't delved into how that's working, but I can take a look at that. I don't know the answer.
Right, I mean, it's plural in the last clause. And in your total record, there may be a number of names that appear. But I take this to mean it's only the person who, if it's a conviction, the person who is convicted. If it's a.
Right, that's my interpretation, but I hear your point, and I would need to look at the language a little more and probably speak with the juvenile
I
defender.
would only read it then to say they are only upon petition by the person who is subject of the records and only to said person.
Well, I don't know that you need that final clause at all.
What, probably you're right.
What if you just put a period after records?
I would say maybe you wait and hear from witnesses about how it's working, because
Jennifer Micah is
have
Jennifer Micah is
consistency
here.
between the two.
Jennifer Micah.
Right.
Okay.
Is Marshall testifying, or?
He's going
Oh,
to
if he's
join.
here, I can't see.
Ejected.
Okay.
I'm gonna try and join.
Okay. So subdivision 2 is that upon confidential motion of any department or agency that was required to seal their own records pursuant to a court order, that the court can permit that entity to inspect its own files and records if it finds circumstances in which the entity requires access to the files and records to respond to a legal action, a legal claim, or administrative action filed against the entity with respect to that particular incident or persons that are subject that are the subject of the records, and that they're only unsealed for a minimum amount of time necessary to address the circumstances that are the basis for the petition.
So am I understanding that correctly, that only in those instances, legal action, legal claim, or administrative action filed against the department, could they petition?
Well, there's more subdivisions,
I
but in
realize
that particular circumstance, yes.
Okay, I thought that there were 3 iterations of different, but anyway, maybe I'll just hold my question until you go to the other 2.
Okay.
So
So this is one with they're defending their act, they have to defend themselves in a particular action that involves that incident, that defendant.
But I still have a question. So I'm wondering, it says, unsealed only for the minimum time necessary. Well, can't somebody go into the camera and record the whole thing? You go in, everybody's got a cell phone with a camera. Why wouldn't you just go in and? I mean,
You mean,
well, this is
You mean
about the
to-
agency, but I mean,
well, it doesn't talk about, when you're allowed to inspect files and records, you're not supposed to go in and then take pictures of them
well,
and then copy them so that you have them forever,
That's what
and then they
someone's
get
going to
closed.
do.
That-
clearly, I mean, unless a person is sitting in the room with the person, clearly somebody might put copies, take photographs in whatever sections they want, feel they need.
There is a provision though that anybody who releases. that
Later on, we
information-
have,
No.
we have a section on unauthorized disclosure. I think probably rise to that level, Senator Nick.
Yeah, I mean, I've seen people be looking at records.
I mean, I think with all of this accessing sealed records, there's there's a large degree of trust that you guys have invested in the people that are the holder of records, that when you say a record is sealed, that it actually gets sealed, and that when you say you don't have access, you don't actually have access unless permitted, and that people follow the rules.
Or even with expungement, we trust that they are actually destroying them and not just
Right.
Right.
saying they destroy.
Right. I mean, I certainly hear your point. I think it is something that is more a broader issue within the whole.
No, yeah, it hasn't
thing
been
of with
20 or
sealing.
30 years.
But
Go ahead, yeah.
we create a crime of
No.
for unauthorized use of the records and so forth. So that's later on. When we get to that, I think that takes care of any concerns there.
So at the bottom of the page, so subdivision 3, this is just applying to the Department for Children and Families. So upon motion of DCF, the court can permit DCF to inspect its own files and records. And you see at the top of page 22, the standard, if the court finds extraordinary circumstances in which the state's interest in protection of a child clearly outweighs the purposes of the sealing law and the privacy rights of the person or persons who are the subject of the record, and that unsealing that record is necessary to accomplish the state's interest in protecting a child. The motion can be heard ex parte. If based on court affidavit, the court finds a compelling purpose exists to deny notice to the subject of the records and files, when considering whether or not to grant the order. You'll see if the order to unseal is issued ex parte, the court shall send notice of the unsealing to the subject of the files within 20 days, unless the department provides a compelling reason why the subject of the files should not be notified. And then again, there's that standard on lines 11 through 13. It's only to be unsealed for the minimum amount of time necessary to address the extraordinary circumstances. So subdivision 4, it's upon, so something similar, but applying to law enforcement and criminal justice agencies. So upon confidential motion of law enforcement officer or a prosecuting attorney, court can permit department or agency to inspect its own files and records if they find extraordinary circumstances in which the state's interest in public safety clearly outweighs the purpose of the sealing law and the subject of the record's interest in privacy.
I just want to say I appreciate that language, extraordinary circumstances, and then clearly outweighs, that gets repeated in all of these, because it makes it very clear that it's not to be a sort of casual thing that you would, as a judge, lift the.
Right. I do remember working on this with this actually committee, whatever. And the committee spent a long time trying to come up with working with stakeholders and stuff, coming up with these standards. And so trying to get at, the option of being able to, when you do need to really access a record, but having the court be the check on that and balancing the interest and determination whether or not the agency should be able to access the sealed file. So again, it's modeled very similarly after the language up on DCF, but this is for law enforcement and prosecuting attorneys. So the order for unsealing has to state whether the record is unsealed entirely or in part during that period of unsealing. And if the court's order unseals only a part of the record, or only unseals a record only with respect to certain persons, the order has to specify that. And that's it for this one. Again, it's just modeled verbatim after what you have in the 33 VSA 5119. So I think if you, as you go through this, if you want to.
We didn't do page 25.
I thought there was a section on unauthorized disclosure that you worked on, Michelle.
Yeah.
Oh, I'm not done with the bill. I just meant that section. I'm sorry, I just meant that particular issue with access to sealed records.
Okay.
So you're right.
All right.
So page 25. So page 25 is the new language that I added to section 7 for unauthorized. And then you'll see I added the words access or disclosure because Philip had raised the issue about, well, what if you're just looking and you're not actually going to disclose that further, but you're still accessing in violation of what the spirit of all of this is. So I added access. And so there, and Philip also raised the concern about, well, if it's in the course of their official duties and
Is that meant to be struck?
yes,
Okay,
that's meant to be struck. And so I reworded this a little bit so that it's who knowingly accesses or discloses information obtained within the scope of their official duties, because I think what you had raised, which I think was a valid point, which was that the way that it kind of read before was that if you disclosed as part of your official duties, but maybe you access, you accessed it, but you wound up disclosing and it wasn't part of your official duties, but you still accessed and disclosed.
well, if we get rid of obtained within the scope of their official duties, you still have without authorization.
Right.
Well, what I was trying to get at there and is that there was a concern, and I think it was the network. It might have been the Center for Crime Victim Services or both. I'm sorry, I don't remember who it was. Had raised the issue in the House is that they wanted to make sure that this couldn't be interpreted in any way to apply to a victim who has information about a case and that they then share information. They wanted it to be tied to someone who.
Well, this is employee, contractor, or agent of the court.
That is true, right? So maybe that takes care of it. Yeah. So maybe you don't need the obtained within the scope of their official duties.
Because I think that's the problem, is that it's useless if somebody obtains it outside the scope of their official duties.
Or discloses it outside.
Right. But if you get rid of obtained within the scope of their official
Right.
duties.
That may be fine. I would just say you might want to hear from them to see whether or not that, because they did have a lot of concerns in the House about this particular
wouldn't
language.
touch any victim.
No.
And I will say is that this was originally modeled after, and this has changed quite a bit, but as the bill was introduced, it was modeled after what you have for unauthorized disclosure statutes in Title 20 with regard to criminal history records. And it didn't specify that it has to be state, municipal, whatever. And I haven't heard that there have been issues around, anybody going after victims about that. So you can weigh whether or not that's, it's a real concern or not.
So I have a question too. So I'm thinking about the employee that's charged with finding this piece that everybody's finding what people are looking for. And they access stuff, they have to look at stuff in order to find what the people are looking for. So they knowingly access it because they're searching through to find the information that the person who's allowed to have it needs. So the employee accesses, like they're going through files trying to find the section about this person, and they access it. But I mean, I see that
But I think that's covered because they'd be authorized to do what you're describing.
It says there without authorization on line 7.
So to me, it applies to,
Yeah.
yeah.
I mean, they couldn't be charged for accessing it anyway.
And
And
they-
it says a separate penalty.
But the
That's only disclosure.
disclosure could be outside there. So they get the information, they're authorized to get it, and then they're at a dinner party.
Yeah, no, I know that.
And they
part.
start
Or
talking about it.
take Alice's point about somebody using their cell phone.
Yeah,
So it happens that somebody works in this office and in the record is something that a friend of theirs might
Yeah, well, that
be
would-
interested in, and so they text them a
Yeah.
picture. That
would clearly be wrong.
Yeah.
I mean, I'm just thinking they're going through it as,
Yeah, no, that person wouldn't be.
because they are authorized.
From a practical standpoint, are we talking digital or paper or both?
probably both.
And who is the gatekeeper for digital records?
Oh, God.
Where's the custodian?
Custodian, yeah.
Paper situation, I can see boxes that have tape wrapped around them saying
Right.
sealed. But
I
don't know how that
think We did hear from someone in the court how those files are, at some point in some of these
Yeah.
discussions, we heard from someone about those digital files as well, and how they are protected. So we did hear from someone.
Okay, let move.
What's that?
Can we move along?
Oh. Okay.
So that's the end of the changes for this draft.
At
So-
the end.
We're at the end.
I
At the
really, I have to say, I really like that way of squaring the circle so that we're allowing access with court order under extraordinary circumstances. That eases a lot of my anxiety about getting rid of expungement and replacing it with sealing. But I imagine there will be, people in the public safety
I think-
community who feel
I think,
somewhere.
yeah, we're gonna hear testimony, I think, from the Department of Public Safety, state's attorneys and others about the need for access for a certain period of time. And going back to David Diamora's testimony about when something is useless. And, we'll hear that. And I personally, if it helps us move the bill forward, don't mind giving some access to law enforcement and others for a period of time after the file is sealed, but there has to be a point where nobody gains access to anything without a court order. So that might be what we might hear. I've talked with the Commissioner of Public Safety. I've talked with Evan Meenan and John Campbell. And so, be prepared. The other, if we can't come to some resolution, fine. But, we make our best effort to come to something that works for the majority of cases. And I'm knowing that the Attorney General still favors expungement. This is controversial stuff, but it's also technical and how you get access to records. But I do think the juvenile system has some advantages over what was portrayed in the House passed version of the bill. So I'm going to jump to comments.
I just want to say, I like this as a compromise, but I personally, I couldn't go to allowing open access for some period of time, because I just feel like that's set out to do and promised to do with expungement. I think then you just go back to a system for that period of time where the person has no privacy of that record. So I just don't want to misrepresent where I am. I couldn't vote for a bill that goes further than this one in that way.
Okay, that's fair. Well, let's see what happens. We may be at a point where we add a couple of crimes to the existing category and go to conference. I should say the existing structure of expungement. So anyway, why don't we hear from Jennifer Micah first, and then Tucker Jones, and then Evan Meenan, and there may be some others on the line. Jennifer?
Good morning, Senator Sierras. For the record, I'm Jennifer Micah, General Counsel for Vermont Department for Children and Families. And I'm here to talk about H534 and some of the issues that DCF hopes you will consider when you think about this bill. Last time I was here, you asked that we come back and talk to you about how our process works. So I just want to spend a few minutes on that. Reports of child abuse or neglect come into our centralized intake and emergency services line. And when appropriate, when it's been accepted, the report is forwarded to the Family Services Division for investigation. At the conclusion of the investigation, the division determines if the allegation should be substantiated or unsubstantiated. In order to substantiate an allegation of child abuse or neglect, we must determine that a reasonable person would conclude that the child was abused or neglected as defined within the statute. And unless it's related to sexual abuse, that the individual who committed it is a person responsible for the child's welfare. The issue that comes up with the sealing of the records is when DCF does joint investigations with law enforcement. We are both empowered and required to perform joint investigations with law enforcement. We are required to report to and receive support from law enforcement in certain types of crimes, such as lewd and lascivious with a child, human trafficking, and sexual assault. And those, by and large, are the cases that I'm thinking about when I am thinking about talking to you today. We have to seek out and rely on information created by law enforcement. As you might imagine, many times we don't want to have to re-traumatize victims, so there will only be one interview of a victim. Sometimes a social worker is there. Sometimes there's a request that the social worker not be there, which means that we then would have to rely on the affidavit of the law enforcement officer who performed the interview with the victim. Recalling too that many of these victims are quite young as 3, who are verbal. Other children, of course, are not verbal, and we rely on other ways of interviewing those children. Sometimes we are directed not to perform the interviews by law enforcement, in which case we don't. Other than that, these are parallel processes. They are not one process. Our process is essentially a civil process, and then there's the criminal process. During our investigation, we accrue our own records. Our social workers take their own notes. They might rely on, like I said, the affidavit of the officer. They might talk with the officer or other individuals involved in the case, but they are parallel and they're not always, they don't overlap in every factual situation. Importantly, there are different legal standards. The standard, as you know, in a criminal case is proof beyond a reasonable doubt. And in our case, as I said, it's a reasonable person standard at the point of placement on the registry. After that, if a person is placed on the registry, when it goes to if the person appeals it to the Human Services Board, it becomes a preponderance of the evidence standard, which is, as you know, about 51% likelihood. Different evidence may be relevant in the different cases. There may be elements of a crime that are not required for us to prove at the level of the review for substantiation. And so a person can be found not guilty in a trial, or a case may be dismissed by a prosecutor because of lack of particular element. But for our purposes, there may be sufficient information and evidence to compel a placement on the registry, compel a substantiation. There are processes for an individual to contest a substantiation. When our Family Services Division recommends a substantiation, a letter is sent out to the alleged perpetrator, who we call the grievant. They may ask for a review. Our reviews are performed by what we call reviewers, and they are independently contracted individuals. Go ahead. I'm sorry, what? I thought somebody else.
No, that was just a stray cough.
Okay. So we have the reviewers, and the cases are sent to the reviewers, and the burden is on the department, as I said, to prove that it accurately and reliably concluded that a reasonable person would believe that the child had been abused or neglected. The grievant is permitted to bring in information, to present documentary information, or they may come in and present their own, sort sort of testimony. It's not a formally sworn in kind of review, but they might come in and talk to the reviewer. And then if the Commissioner's Registry Review Unit reviewer determines that it should be substantiated, the person then has another opportunity to appeal that decision to the Human Services Board. Under the statute, when a person is substantiated at the review level, they are placed on the registry. That is not something that DCF has any control over. In addition, after the Human Service Board case, an individual has a right at a later date to seek what we call an expungement, not to confuse things too much, but you can get your name expunged from the registry at a later date by coming in with information showing that you have taken action or that there was a gross miscarriage of justice, wrong, victim lied or something like that. You can come in and you can petition directly to the Commissioner of DCF to be taken off the registry. The concern that we have is largely due to the difference in standards. And importantly, DCF is, unlike the criminal justice system, we are interested in prevention. We're interested in assuring that other children will not be harmed by the actions of somebody who we know has harmed a child in the past. And what the legislature has allowed for and dictated is for this process to proceed. Last time I was here, Senator Benning, you were talking about what happens if you have a not guilty verdict in a criminal case. And I mumbled my answer, jumbled my answer. But the answer is we do in fact place people on the registry even if there is a no conviction in a case, whether it's a not guilty or whether the case has been dismissed with or without prejudice. A person can be placed on the registry, and that is because of the different standard of review. So what might not be good enough for beyond a reasonable doubt will be good and potentially will be good enough for placement on the registry, so that an individual who's applying for a job or volunteer opportunity that involves direct interaction with children very often won't be a harm to other children. And I would encourage you to think about, as you consider this, the fact that many of our victims in these cases are young children. And young children, as you know, don't like to testify. And many, many victims choose not to come forward after they have made the initial allegation. And yet, the initial allegation is very believable. I would like to bring to your attention a recent case that we've had where we had a child who came forward by alleging abuse by a caregiver. And that caregiver was criminally charged, and they also had a pending substantiation. We received, when the grievant came forward for the review, they came forward with an order that the record was sealed. This was before we had completed the review. And when the grievant told the reviewer that the victim had recanted. So the reviewer sent the case back to the social worker to reopen it and look into it again. The social worker called the state's attorney. The state's attorney told the social worker that that was inaccurate, that it hadn't been, that the victim had not recanted, but that the victim did not want to testify, that she was getting a lot of pressure from her family, and that the prosecutor had made an agreement with the grievant to undergo treatment, and that the grievant had completed that treatment. When I heard that, I thought, why did the state's attorney think it was okay to talk to the social worker if the case had been sealed? And so I called the state's attorney and I asked that question. And the state's attorney said, I didn't know the case had been sealed. Somebody else in their office was doing the sealing. Cases without convictions are sealed as a matter of course. If you look at 7603 as it currently exists in statute, almost anybody can get a case sealed if there's no conviction within 60 days. And according to the state's attorney, it was a deputy state's attorney, just to be clear. According to the deputy state's attorney I spoke with, she said they are routinely granted without a lot of review. And I'm not surprised by that. The other thing she said to me was she didn't realize that it would affect the substantiation. She said the first words out of her mouth was, it's a different standard for review. So I think that one of the problems, yes, go ahead, Senator.
Mr. Chair.
Yeah.
If I might. Jennifer, I'm trying to follow the ins and outs of the case, but I'm wondering, I'm having a hard time understanding the relationship between what you're testifying and what we're doing. So I guess my understanding is that if the concern is that someone who abused a child would have their record sealed and DCF would not be allowed immediate access to it, under this, DCF could still petition for access, but I don't think that that crime would be sealable. Michelle, am I right in that?
Correct. No child abuse or neglect offenses are eligible under this proposal. No sexual violence crimes, anything like that. Those are not eligible to be sealed under the bill.
So,
But it was no conviction.
That's how the bill would be affected, is if there's no conviction, we're sealing it. Is that correct?
That's the current state of the law,
That's
and that's
current
not being changed. That's not being changed, though. 7603 isn't being changed, I don't believe.
right. So I guess my question is, this bill doesn't set up that situation. Is your testimony that you want the bill to close that loophole, or do you have a problem with the
Yes.
structure that this current draft sets up, where there's a court order necessary?
Right, so both of those. So it has only been in the past, in talking with our CRRU, our Commissioner's Registry Review Unit, it appears that this issue has really arisen over the past couple of years as sealing and expungement has become more common. And so it's happening to us more frequently that people are coming in for reviews and a case has been sealed or expunged. And by and large, it has to do with cases that that do not result in a conviction for the reasons I already talked about. So we would like, as the language that I recommended last time, is that we would like to be allowed to continue to access our own records. We're not actually asking for the criminal court to release any records to us. We're asking that at our reviews, regardless of what happens in the criminal matter, that we continue to have access to the records that are already in our possession. That's different than what is proposed in the bill. Senator Bruce, I know you said that you really like that language. And when I look at that language, I see a lot of process. I see a lot of time elapsing. I see a lot of court resources. And I also know that our assistant attorney generals already have a lot of work on their plates. And I suspect that if you were to talk to the attorney general's office, they might not be too happy about asking that every time we need to access a sealed record, we have to go into court and prove an extraordinary circumstance. I would perhaps, if we had some kind of exception around access for purposes of determining the licensing for child care centers and for foster families. That would be a nice exception, as well as access to our records for purposes of following through on a substantiation review of the underlying case.
But, okay, I'm, it's an interesting concept here, access to your own records. How long are, given the nature of the crimes, you just want access to I'm with Senator Baruth. I'm perplexed here. You want access to your own records of cases that have been dismissed by the court.
Right.
Person
So when
X
we
is
do it,
charged, but if person X is charged with child abuse, this is where I'm having a hard time, and I think Senator Baruth is too. Maybe I'm asking it a different way. If the person is charged with child abuse, it can't be sealed or expunged, but can it be? But if they're not found guilty, that's what you want? Access to?
So I am, as Senator Baruth noted, I am looking for some access that we currently do not have. So yes, I'm asking for a little bit more than what is the scope of this bill. And I am concerned that the language in the bill is going to make it even harder for us to get that. There have been Supreme Court decisions that have said that DCF cannot access its own records in these substantiation cases. And that's why that's part of the reason I'm here today. We need to access.
I appreciate that. And I'll be honest with you, I'm just totally disappointed. This is our third attempt at trying to improve the lives of people who have been convicted of crimes, minor in general, they're minor, to be expunged or sealed. We've been through this thing so many times, and there's like this thing that is cropping up, and I'm trying to be consistent here and say, at what point is this information worthless to an investigative agency? Maybe it's.
Can I just ask a clarifying question? Jennifer,
I'm in the midst of can I just finish, please? Yeah. I'm just trying to express my frustration here at trying to accommodate these issues, but I'm having a hard time understanding how we are supposed to get through this damn bill. I have been spending so much time on this. It's a pretty simple concept. At some point, if you committed a crime or allegedly committed a crime, and the case has been dismissed, at some point, that information is worthless, because people do change and things change. And so what we're trying to do is find a way to seal some of these records, because the governor didn't like expungement. I am so frustrated. I'm just pulling what little hair I have left out. I'm trying to work with the state's attorneys, trying to work with the Department of Public Safety, and giving some extra time before the thing is sealed forever. But at some point, I have to say, this is not worth it. So now you want us to go back further and change current law. That's just bizarre. I'm sorry, but I'm frustrated. Senator Benning, go ahead.
Senator Sears, this bill deals with a criminal history record. And Marshall and Evan, I invite you to join in this conversation. When I get a criminal history record, there isn't anything on it about somebody being substantiated or not by DCF. And I'm trying to figure out, are we talking about something that really isn't relevant to this bill?
Evan, go ahead.
Thank you very much. I thought it might just be helpful in response to that comment, Senator Benning, to remind everyone what we're talking about in the context of sealing and expungement when we refer to a criminal history record, because I think that is what is causing many of the concerns that you're hearing from folks like myself and VSP and DCF. Criminal history record is not just the entry of a conviction on someone's criminal history report. It actually is all information documenting an individual's contact with the criminal justice system, including data regarding identification, arrest, or citation, or arraignment, judicial disposition, custody, and supervision. So it is all of the police reports, all of the affidavits, all of the audio recorded statements. It's close to everything in a case file. And I think that's why, for example, I've been raising concerns about discovery, because we might be talking about things that don't really have to do with the defendant per se, but might have to do with a witness, a victim, or a police officer. So it's not always about using a defendant's conviction against that same defendant in a future case. Sometimes it's about disclosing something that a witness or a victim or a police officer said or did to a completely different defendant in a completely different case. So I think it's helpful to keep in mind how broad that definition is when we talk about sealing and expungement.
Well, Evan, this bill is targeted only at a criminal history record, and NCIC has that record. I cannot, in 38 years, ever recall getting an NCIC record that had some notation of DCF substantiating an individual. So I'm trying to figure out, are we talking about something that is really not impacted in this witness's testimony? Because I don't see DCF and its records falling into this bill.
Well, I think that's what I was trying to explain, is when the phrase criminal history record might mean different things in different contexts. Like if an attorney shows up for an arraignment and we're talking about a criminal history record, we're thinking about like a defendant's rap sheet, right? But that's not what criminal history record means in the expungement context. Criminal history record might include a police report that explains the allegations that might lead DCF to substantiate someone for child abuse. So
the issue here, though, for DCF is whether they can have access to their own records.
That's right. So if
this bill says that the petitioner can move to expunge a DCF substantiation.
Right. So the issue is this: if law enforcement provides DCF with that police report that I just described, and then later on the case is sealed or expunged, that expungement order arguably applies to the police report in DCF's custody because of the breadth of the definition of criminal history record. So if DCF then has to either seal that report and can't access it, or they have to destroy that report, I think what DCF is saying is that creates a real barrier for them to complete their substantiation process.
Mr. Chair?
Yeah.
If I could just jump in, I feel like in this discussion, we constantly move away from the idea that in law now we have expungement, and we are responding to complaints about expungement, and the clear direction from various stakeholder groups was, could you please move to a less burdensome, less confusing, less administratively complicated system that would be sealing. So when Jennifer Micah is talking about this bill would increase administrative burden, I get a little confused again, because what we're doing is getting rid of the very time-consuming process of actual expungement. And we're replacing it with something that's administratively much easier. Now, that doesn't understand that from probably the Department of Public Safety, state's attorneys, and DCF, that will be a sticking point for you, because nobody wants to have to go to court to get access to their own records. But just on the question of administrative burden, if Senator Sears were to say, I've had enough of this, we're getting rid of this bill, then you're left with the current system, which everybody has described as in need of reform and move to a single track. So I don't know, I feel as though this bill creates a better situation in many, many ways, but the sticking point for your various groups may be that court order. And I don't think there's a way necessarily around that if we're going to have sealing that's meaningful.
Yeah, and I'm happy to address the court order piece, which was something I was going to do in my testimony, and I don't want to jump the gun, but I'll definitely respond to your question, which is a good one, because I think it really identifies where a lot of the tension in this conversation is happening, because I think that people might have had different expectations of what it, very early on, about what it might have meant to move to a one-track system. I think that in some people's mind, when we were talking about moving to sealing, we thought that wouldn't necessarily come with changes to what the effect of sealing is and what government access to sealing records was. That might not be universally true, but I think some people made that assumption. So what we're seeing is, you're right, on the one hand, since we're expunging fewer records and sealing more, on the one hand, that creates some additional access that was not previously permitted. But on the other hand, if we start changing the degree of access to sealed records, we're losing access on the other hand. So for example, this bill right now, under law for sealed records, the prosecutor has access to sealed records for discovery purposes. Under this most recent version of the bill, the prosecution has no access at all to any sealed records for discovery purposes whatsoever. So that's a really big change. So it's sort of like two scales moving, and it's like, what's the delta between where the two scales are?
If I could, Evan, again, it's the change is moving from expungement, where you have zero access, to sealing, where you would have access with a court order. So I understand that that's not the case with the new crimes we're adding, but if you put the new crimes to one side, this bill gives you substantially more access to those things that are already considered for expungement, because under current law, current statute, the changes we've already made, you would have zero access. So, I feel as though it's inaccurate to keep characterizing it as though you're losing access. DPS, DCF, anybody is gaining access under this bill to the crimes that already qualify for expungement, because they're not going to be destroyed and they will be accessed.
And I think on that point, Senator, we might just have to respectfully disagree, because you're right on the one hand. If you talk about just the number of cases that there's some access to, but if you talk about what that type of access is, it's significantly more limited. And I want to say it's not because of the court order piece. And again, I can explain that when it's my turn to testify. But right now, because of the definition of criminal justice purposes, the prosecution, for example, has access to sealed records to assist in an investigation, for example, sealing, reviewing search warrants, things of that nature, and also has access to sealed records for the adjudication of criminal offenses, which would include providing information in discovery. Under this new bill, law enforcement or prosecutors would only have access if they can show that the access is necessary for public safety. That's not always going to be true for discovery. So it's not accurate. I'm sorry.
Let's take a step back. I heard complaints about the House passed version. So I said to the Commissioner of Public Safety, would you accept something like the juvenile sealing law that's been on the books for a long time? Evan, I'm actually talking to you. You don't have to go off. Jesus, Marion Joseph. I'm trying to understand, and maybe anybody can help me here. What's wrong with the House passed version? That's what I heard. So I tried to come up with a compromise. Throw the damn compromise out. If, what I heard, when the Commissioner of Public Safety said he would accept the juvenile system, that's why we did that. But evidently, that doesn't work either. So what is it about the House bill that you don't like specifically? What would you like changed? And secondarily, I'm trying to get my arms around how long is something useful. For example, the most serious crime I think we have on here is a felony of burglary, excluding burglary into an occupied dwelling unless the person was 25 years of age or younger. So a 19-year-old commits a burglary, is charged and convicted of that burglary. Now that 19-year-old has waited 7 years. He's 20, I believe he's 26 now, 27. Let's say he's waited 7 years, which is the requirement for the felony, right? Now, that record is eligible to be sealed. So he's been in no trouble since he finished all the requirements at 19. So let's just say it took him he was on probation or did some time, 3 years to complete everything that was supposed to be done, then another 7 years. So now we're 10 years, he's 29. He applies for expungement, state's attorney, court, everybody agrees that it should be expunged. Under this scenario, it would be sealed, okay? So now we're 10 years down and we give an extra 7 years, let's say. So now he's 35 before everything's sealed. At what point is it useless to have that record for anyone? That's what I'm getting a hard time with, because
yeah, and I think it's a good point. And the state's attorneys, I think, would acknowledge that at least for public safety purposes and also likely discovery purposes, we're going to reach a point in time when the lack of access to records is going to cause very few issues. But the department was initially very optimistic about this idea of looking to the juvenile statutes, specifically 33 VSA 5119. We thought that was a great idea because it could hopefully check off two boxes that were on our March 15th memo to this committee that listed the things that we took issue with in the House bill. And those two things were, in the juvenile context, any entity that possesses sealed records can maintain an index or generate a report of those sealed cases. And that's really helpful from a public records perspective, from just making sure that there's no erroneous disclosures that could get people into trouble later on. So we thought that was going to be incorporated into this bill, and unfortunately it wasn't. So we have been asking for permission to maintain an index. We can maintain an index for juvenile records, but this bill doesn't allow us to do that for adult records. And then the other thing that we were hoping could be accomplished was incorporating the process for the prosecution to get access to records by getting a court order. But we were hoping that in addition to access for public safety purposes, we could get access for discovery purposes. Because after all, if we're talking about promises to Vermonters, the Constitution promises Vermont defendants that they will have access to potentially exculpatory evidence. So we were hoping with that tweak, we could satisfy two of our concerns. But again, this bill actually eliminates all access for discovery purposes. Courts generally don't like getting involved in discovery issues, but if we have to get a court order, that's a system that I think we could work with. But Senator Sears, to your point, I think it's a valid one. What are we talking about? Are we talking about 10 years, 8 years, 15 years? To a certain degree, finding one universal timeline is going to be a little bit arbitrary. But if that's what the direction the committee wants to go with, I think you're just going to have to pick a number, and we'll do our best to work within the confines of the new law.
Okay, and it's access to your own records, right?
For discovery, that's what we're talking about. Yes, if we have some statement by a witness that maybe they provided some false information, or a video showing that maybe a cop mishandled evidence, we need to turn that stuff over. It's important so that present and future defendants don't have cases that are negatively impacted because of a promise in statute to a prior defendant.
Okay. I don't know where I'm at. Was that something, Michelle, that wasn't part of the juvenile bill, or you didn't add it, or was there a reason?
The issue around discovery is not a part of the juvenile sealing bill. So that was something that was discussed in the House, and there is a provision in the House passed version around that. I think there's differing opinions about whether or not that's necessary, and from the various witnesses. So
Yeah, I was going to say, I think judging from his facial expressions, Marshall Paul has something to say.
Go ahead, Marshall, go ahead, and then we're going to take a break because I need one.
So I did not mean to reveal anything with my facial expressions, but when it comes to just to address this issue of discovery, we just profoundly disagree with the state's attorneys on this. This is an issue that has come up in many other states, and in every other state, this has been addressed in decision. And those decisions have all said the same thing, which is that prosecutors do not have an obligation to disclose a record of conviction that has been expunged as a matter of Brady obligation, or as a matter of any type of statutory or rule-based discovery obligation. And in fact, what all of those cases have said is the same thing, which is that prosecutors don't have the obligation to disclose a record of conviction, because if it's been expunged, because it can no longer be used to impeach. And the entire purpose of that type of discovery is to provide evidence that can be used for impeachment to the defense. And because it's no longer a conviction, it can no longer be used to impeach, prosecutors don't have an obligation to disclose it. That's not to say that prosecutors cannot disclose the underlying conduct. They can disclose that. So, for example, if a prosecutor's office is aware that someone has lied on the stand, they can disclose that to the defense. That's not the same as having the prosecutor disclose a record of conviction, for example, for perjury to the defense, if that had been expunged, which I have not seen records of perjury getting expunged, but if it, in that scenario, the point being that you can disclose the underlying conduct without disclosing the record of conviction. This has been really consistent all across the country. This is not a problem that's, Vermont's the first state to have thought of. In fact, it looks like we might be the last state to have thought of it. And in no state have the problems that Attorney Meenan raised actually been an issue. So from our perspective, and also we're the we're here representing the defense bar. From our perspective, I've asked our attorneys to think of occasions when they have been hampered or hamstrung by, being unable to get information about an expunged conviction, because this is exactly one of these scenarios that's been around for 40 years, 50 years, at least since we've had deferred convictions that result in expungement. We've had records that prosecutors have been completely unable to access, records of conviction, and we have not had this problem come up. None of the attorneys in our system can remember a situation where this problem has presented itself. So from our perspective, this is purely speculative, and something that's been addressed by other jurisdictions.
Thank you, Marshall. We're gonna take a short break, and Tucker, are you able to stick around with us? We haven't heard from you yet, and but I just missed a meeting that I was supposed to be at because we're in this, and I'm sorry. So Tucker,
whatever you want, Senator Sears. I'm happy to stick around.
we'll call on you, and we'll have more of a roundtable discussion on where we go from here.
Okay.
But thank you, Marshall. Why don't we get back together at 25 of 11, 15 minutes.